All right, welcome back to the deep dive. Today we're going way back to 1854 to be precise, for a deep dive into a really foundational legal case. We're talking Hadley v. Baxendale. You know, you might not think a case from the 1800s would have much to do with us now, but this one really set a precedent. It still shapes how we think about responsibility, especially when it comes to agreements and businesses. You know, what happens when things go wrong?
Oh, absolutely. Hadley v. Baxendale, it's a cornerstone case. Even though it's so old, the principle it established, it really makes you think about those domino effects of our actions. You know, how one thing leads to another. It's about more than just this one specific situation with a broken crankshaft. This case, it changed how courts all over the world, how they would go on to deal with breaches of contract for a very long time.
Right.
And businesses, they had to start thinking more carefully, much more carefully about the information they shared when they were making deals. It had a huge ripple effect.
Okay, so let's take it back to England, 1854. We're in Gloucester. Picture this, a bustling flour mill. And our plaintiffs, the Hadleys, they're the ones running it. These mills, they were powered by steam engines, right?
Right.
Big, powerful machines. And, well, something goes wrong. The crankshaft, the main crankshaft of their steam engine, it breaks. And this isn't just any part. This is like the heart of the machine. Without it, the whole mill, it just grinds to a halt.
Yep, a major problem. And of course, to get the mill back up and running, making flour, making money, they needed a new crankshaft. So they placed an order for a new one from a manufacturer, W. Joyce & Co. down in Greenwich.
So they've got the order in, but there's a catch, right? They can't just get any old crankshaft. They needed one made to the exact specifications of their mill. And to do that, the manufacturer, they needed a model, a pattern to work from.
Precisely. And the problem was, the only pattern they had was that broken crankshaft, the one sitting there in their mill in Gloucester. So the Hadleys, they had to figure out how to get this big, heavy piece of broken machinery all the way to Greenwich. And we're talking 1854, so no speedy delivery trucks or anything like that.
Horse and cart, right.
Horse and cart.
So what do? They do what people did back then. When they needed to transport something, they hire a carrier, a company that specializes in moving goods. And they go with a pretty well-known company at the time, Pickford & Co. Kind of like, the big logistics firm of their day, known for reliability. So they hand over this broken crankshaft to Pickford & Co. And they make it very clear, we need this in Greenwich ASAP. 2 days. That's the time frame. And Pickford & Co., they agree. They take the job, take the payment. Seems pretty straightforward, right? A simple business transaction.
It seems like it. A basic contract for the transportation of goods. You take this, you deliver it there by this date. Simple. But here's where things start to go sideways. Pickford & Co., they don't meet that deadline.
Oh, no.
Instead of 2 days, it takes a whole 7 days for that crankshaft to finally arrive in Greenwich.
7 days. That's more than triple the promised time.
A huge delay. And for the Hadleys, this wasn't just a minor inconvenience. Their mill, it's sitting idle this whole time. Every day that crankshaft is delayed, they're losing money, losing potential profits, because the mill can't operate without it.
Right, because the manufacturer in Greenwich, they can't even start making the new crankshaft until they have the old one to use as a model. So the Hadleys, they're out 5 extra days of operation because of this delay. 5 days of lost income.
Exactly. So, as you can imagine, they're not happy. They decided to take Pickford & Co. to court. The Hadleys sued Mr. Baxendale, he was a partner in Pickford & Co., and they sued him for those lost profits, the money they missed out on because of that delayed delivery. And that brings us to the really juicy legal question at the heart of this case. Should a carrier, in this case Pickford & Co., be held responsible, financially responsible, for the profits that a business loses because of a late delivery?
Yeah, it really makes you think. Like, how far does responsibility actually go in these situations?
It does, doesn't it? It's a really important question that comes up all the time.
So let's break down how each side argued their case. Hadley, why did they think they deserved compensation?
Well, their argument was pretty straightforward. They said those lost profits, they were a direct, foreseeable consequence of Pickford & Co. failing to deliver on time. It was a natural outcome. And they pointed out that their servant, he specifically told the clerk at Pickford & Co., that the mill was stopped, completely stopped, and that they desperately needed that crankshaft to get back up and running. And they paid for the carriage, emphasizing just how urgent it was. It wasn't like they just dropped it off without saying anything, They made it clear.
They were definitely trying to show that they took all the right steps to communicate the urgency of the situation. It wasn't just an assumption on their part. But it wasn't just about what was said, right? I seem to remember that they also brought up a bunch of past legal cases to support their claim, didn't they?
Yes, they did. They referenced a whole string of previous cases like Nurse v. Barnes, Bordale v. Brunton, and several others. I mean, it was a whole legal strategy. Their point was, look, courts have recognized this type of loss before. They've awarded damages for lost profits when contracts are broken. They were basically saying, there's precedent here. This is how the law works.
So the Hadleys, they're laying out the timeline, they're emphasizing communication, and they're saying, hey, the courts have backed this kind of claim before. Okay, so that's their side. What about Baxendale, representing Pickford & Co.? What was their defense? Why did they think they shouldn't be on the hook for all those lost profits?
Well, Baxendale, he argued that those lost profits, they were what they called too remote, too far removed from the actual breach of contract. Essentially, they argued that as common carriers, their business was all about transporting goods, all sorts of goods, and they couldn't possibly know the specific significance of every single item they were shipping.
That's a fair point, right?
Yeah.
Like, they're moving tons of stuff. A crankshaft for a mill, well, it's just another delivery in their eyes, right? How could they know that it was so crucial to the Hadley's entire operation?
Right. And they argued that the law, it doesn't automatically cover every possible consequence of a contract going wrong. They use some interesting examples to illustrate their point. Like, let's say someone doesn't pay a bill on time and then the other person, they end up going bankrupt. Well, Baxendale's argument was the person who didn't pay the bill, they're not automatically responsible for that entire bankruptcy unless there was some specific agreement in place beforehand that outlined that very risk. Or if a tarp to cover hay is delivered late and then, bam, a storm hits and the hay is ruined. Is the carrier, the one who delivered the tarp late, are they responsible for the spoiled hay? They argued that those indirect consequences, those are not automatically the fault of the party that broke the contract, unless they specifically knew about that risk or there was some special agreement in place.
So they're basically saying, look, we might have messed up the delivery time, but the fact that the Hadleys' entire mill was shut down and they lost all that money, that's not on us. That's not a direct result of our delay. And they even threw in a fancy Latin phrase to make their point, right?
Oh, yeah, of course. They went full legal scholar on it. They invoked this legal maxim, injure non remota causa sed proxima spectator.
Oh,
It's a classic.
It rolls right off the tongue, doesn't it?
Oh, yeah. And what it boils down to is this. In law, you focus on the nearest cause, not the remote cause. So they're saying the closest cause of the mill shutting down was the broken crankshaft itself, not the delay in transporting it. The delay, they argued, was a step removed from the actual issue.
Right.
And they also went on to say that those cases the Hadleys brought up, those previous rulings, well, they were different. In those cases, the connection between the broken contract and the damages, it was more direct or they involved specific prior agreements.
Mm-hmm. So you've got Hadley saying, you cost us money by being late, and Baxendale countering with, we didn't know the specifics, and those losses, they're too far removed from a simple late delivery. Okay, so you've got two sides, two arguments. What did the court actually decide? Who won this legal battle?
Well, the Court of Exchequer, led by Baron Alderson, they didn't completely side with Baxendale. What they did was they ordered a new trial. They said the original trial, it wasn't done right. And the reason they gave was that the jury in that first trial, they didn't have the right instructions. They needed clearer guidance on how to properly assess damages in this type of case.
So they basically hit the reset button because the jury didn't have the right framework to make a decision. Fascinating. And it's this very decision, this call for a new trial, that leads to that landmark principle we're talking about today, right?
Yes, exactly. This is the legacy of Hadley v. Baxendale. The court, in its judgment, they laid down this two-part rule. And this rule, it's become like a cornerstone for figuring out damages in contract cases ever since. They said that the damages you can claim for a breach of contract, they should be either. First, those that arise naturally from the breach, just the normal consequences you'd expect in that type of situation. Or second, those that both parties would have reasonably contemplated, thought about as a probable result of the breach when they made the contract. This ruling wasn't just about this one mill. It became a cornerstone for how courts around the world would approach contract breaches for the next century and beyond. It forced businesses to think more carefully about the information they share when making deals.
Okay, break that down a bit. The first part, damages that arise naturally.
Okay.
What does that actually mean in practice? Can you give an example?
Sure. Think about it this way. It's the kind of loss that anyone would expect in that specific situation. Anyone who understands how that type of contract works. Like, let's say, a bakery. They order 100 bags of flour from their supplier, and the supplier, they don't deliver. Well, the natural damage there is the cost the bakery has to pay to buy that flour from someone else, maybe at a higher price. They need that flour to keep baking, to fulfill their orders. The difference in price, that's a direct consequence of the breach.
Right. Makes total sense. It's the kind of loss that's predictable when someone doesn't hold up their end of the deal. And the second part, damages that are reasonably contemplated, that sounds trickier, doesn't it? Like, it depends on what each side knew going in.
It does. It's a lot more nuanced. This part is about those less obvious losses, the ones that depend on specific circumstances. For a party to be liable for these special damages, it has to be shown that both parties knew about those circumstances when they made the agreement. They both understood that if the contract went south, it could lead to those specific bigger losses. It's about whether they foresaw, contemplated those risks.
Okay, so bringing it back to the broken crankshaft case, how did the court actually apply this two-part rule to the Hadley situation?
Well, they said, look, a common carrier like Pickford & Co., they wouldn't automatically know that this particular crankshaft was the only one the Hadleys had. They wouldn't necessarily know that the entire mill was shut down and relying solely on the delivery of this one part. They're delivering all kinds of things all the time, you see. Losing profits is not an automatic consequence of just a delay in shipping some machinery, unless, of course, those specific critical circumstances were communicated to them.
So just knowing they were transporting a part of a mill engine, that wasn't enough. Pickford & Co. could reasonably assume the mill might have spares, or that it wasn't such a do-or-die situation.
Precisely. And this is where communication, clear communication, it becomes so vital in contracts. The court, they really stress that if the Hadleys had explicitly told Pickford & Co., hey, this isn't just any delivery. Our entire mill is shut down because of this broken shaft, and every single day you're late, we're losing serious money. Well, then the situation changes.
It becomes a whole different ballgame.
Yes. Then those potential losses, they become something both parties are aware of. It becomes a shared risk. Pickford & Co. knows exactly what they're getting into.
So because the Hadleys, they didn't spell out the seriousness of the situation, the absolute critical need for that part, and the potential for big financial losses, the court said the jury in the original trial, they shouldn't have factored in those lost profits when they were figuring out the damages.
Exactly. So Pickford & Co., they were only responsible for the type of damages that would naturally come from a delay in shipping. Things like inconvenience, the cost of having to track down the shipment, that kind of thing. But those big lost profits that the Hadleys were claiming, nope, those were considered too far removed, not something that was part of the agreement or something that Pickford & Co. could have reasonably known about.
So the key takeaway from Hadley v. Baxendale isn't just about who was right or wrong in this one specific case. It's this bigger principle they established, foreseeability. It's about how much you can hold someone responsible for when a contract is broken. And a big part of that depends on what was foreseeable at the time the agreement was made.
Precisely. It set this crucial precedent that's still relevant today. You're generally only liable for losses that were either a direct, obvious result of your actions or for those very specific losses that you were made aware of, clearly communicated to you when you signed on the dotted line.
And that applies to all kinds of agreements, not just those formal business contracts, right? I mean, think about the agreements we make in our personal lives. It makes you think about how we communicate.
It really does. Whenever you're making an agreement, business or personal, think about the information you're sharing. Are you laying out your needs? What happens if things go wrong? Are you spelling that out? Because Hadley v. Baxendale, it shows us just how risky assumptions can be. Being clear about your needs, about the potential consequences right from the start, it can really make a difference when it comes to who's ultimately responsible if things don't go as planned.
Absolutely. And think about it. Today's world, it's so complex. Global supply chains, specialized services. There's so much potential for things to go wrong, for disruptions to happen, So does this 19th century ruling, even though it's so important, does it really hold up in these modern complex situations? Like, what happens when a cyber attack takes down a major supplier or some geopolitical event? It completely throws a wrench in the works. It's fascinating. Hadley v. Baxendale gives us this principle of foreseeability, but actually applying it in today's world where everything's so interconnected, while it gets really complicated, raises all these new questions about responsibility and shared risk, and it really makes you think just how far can this idea of contemplation go in a world that's more connected than ever before?